Hello, and thank you for joining us today on the Ask Andrew Show, Canada's first Facebook live streaming Q&A show. My name is Andrew Feldstein, and I'm the managing partner of the Greater Toronto Area family law firm, Feldstein Family Law Group. I practice exclusively in family law in the province of Ontario, as well as 10 other associates that do the same thing. Today, our special guest is Toronto Estates and Trust lawyer and mediator, Ian Hull, and we'll be discussing how divorce and separation affects estate planning. Please feel free to ask questions in the comment section. Thank you for joining us today, Ian.
Thank you, Andrew. It's a pleasure to be here.
And I do appreciate you taking time out of your firm retreat to join us today. Our first question is, how did you get into estate law, and can you tell us a little bit about yourself?
Sure. Thanks so much. I, too, have a boutique specialty firm. We just do estate-related matters, both contentious and non-contentious matters. So if people are doing classic planning work, we do that work, but we also do matters that involve some contentious court work as well. How I got involved in this area was I got a job from my dad. I started working with my dad about 20 years ago and had a great opportunity. A little more than 20 years ago, he's passed away now, and we've now got a boutique law firm with 18 lawyers who do just estate-related work.
Now, I heard you say that you do estate planning, and earlier this week, as an example, I was speaking to a group of a couple of hundred of accountants about family law. And one of the things I always caution them about when they're involved in estate planning is how it may impact the people who are doing the estate planning. And I was wondering if that's something you have discussions with your clients about.
I do. I think the problem with estate planning is it can be, if it's done in secret, it can be very, very harmful to within your own family unit as well. But I keep saying to my clients, look, we have to bring in your allied professionals to make sure we're not going down a route that doesn't make any sense from what something else you've been doing. And for example, an easy illustration in area family law is when someone comes to see me, I make sure I ask, do they have a separation agreement? Do they have a co-ab agreement? Things like that, to make sure you start to get the puzzle pulled together, both with your advisors. And then I'll also say, what are you doing? What is the nature of the extent of the communication you're going to have with your family?
See, one of the things I like to warn people about when I get consulted on these kind of issues is, even if they think everything is great with call them the in-law child, they don't appreciate that the moment they start transferring shares to their child, that if their child gets divorced, it now opens up everything in terms of financial disclosure. And I was wondering, how do your clients react to that kind of issue when they hear about it?
I'm sure you get the same reaction. It amazes me how little the clients understand what tax-driven steps like an estate freeze that might send out some shares to your children has on your control. And control is everything. And so I make sure my clients understand the nature of the control they actually have now, and whether the corporation has started to shift out some shares to their children. It's the classic scenario. I call it pillow talk. I mean, at the point in time where you think you've got great cohesiveness within your family, it can be changed overnight by a relationship or the ending of a relationship. And I make sure my clients understand that, at the end of the day, if you want to give up control, then that's got to be part of your planning, part of your tax-driven decisions, and part of how you want to manage your family relationships.
And the thing I tell my clients when they come in is that the appreciation is the moment you start transferring shares. If your child splits up with their current spouse, you can expect that there's going to be a demand to see your financial statements, your bank statements, your general ledgers, all of the corporate information. And I know as a business owner, if my kids are far from being of the age to get married, but I would not want to give that information. And that's a piece that I find when clients hear it, sometimes they say, well, then I'm not doing it.
Yeah.
Which I get.
And that's an informed decision. What worries me the most is that they come to me too late, and they've already got an apparatus corporately that I can't really fix that problem. And there are corporate remedies and corporate rights that are there that are going to be, from my perspective, the horse out of the barn. So then it starts to becoming a question of managing the relationships and thinking a little differently as how you're going to approach your children, how you're going to approach the relationships that are around you.
Which I totally agree with. And I know we have a question I'm going to get to in a minute, but it leads me into, I know some corporate lawyers will say, well, we can do a shareholders agreement. And I always say to myself, hold on a second. If you go to the family law defines a domestic contract as a contract between two spouses that can impact, as an example, their property rights. So I've often wondered, why wouldn't a shareholders agreement the two spouses sign not be a domestic contract, which then creates all sorts of obligations of financial disclosure by entering into it that you wouldn't need in an ordinary shareholders agreement. So that a lot of clients aren't appreciating that shareholders agreement may not be the saving grace that they want it to be. And I don't know if you experience the same kind of
legal perspective that you've described, but also, you know, at the end of the day, these shareholders agreements just create possibilities of giant litigation. And, you know, I want to make sure my clients understand that, you know, you're walking down complex, you know, vicious litigation in some of these circumstances, because shareholders agreement fights are personal. They're not necessarily driven by, you know, sort of corporate entities that don't really have any personal attachment. If you've got a family-held corporation and you've got a shareholders agreement that's governing it, that fight is going to be driven not just by economics, but by emotion.
Oh, absolutely. Now, there's a question that came in, and it's about, and I think this large part may be for you, Ian. How does my spouse's death after our divorce affect my entitlement to equalization?
Well, it's a great question. And one of the things that you know, there's two parts to that. One is you know, I remind my clients, marriage revokes your will. And so if you have divorced, that's, you know, your relationship with your will has not changed necessarily. You have a certain limitation period under the Family Law Act in terms of making claims for property after divorce. But in this situation, when you have a divorce couple, you know, I see many times where a will hasn't got changed, or a divorced couple have decided to maintain their gifts under the will. It will largely depend on the nature of the arrangements that you have made after your divorce, and you know, looking at the will, looking at any agreements that were entered into. But on the other end, when you're getting married, it's a full stop. In Ontario, interestingly, there's progressive thinking out in British Columbia about this, and the acts have been changed. But in Ontario, marriage revokes the will.
Now, I've always said to clients, it's one of the questions I often get from a client: should I change my will now that I'm separating? And I always say to them, absolutely you should, because in the worst case scenario, your spouse just has a claim to the equalization payment, and any claim she may have as a dependent. So what you're doing is you may be making sure that they're not getting everything, but they're getting what they're legally entitled to. And I don't know if you view it the same way.
I agree, and I'm actually more urgent with that in some respects. And family law lawyers and we work together collaboratively, and there's a lot of synergies between the advice we give. And one of them is exactly that. Like I say to my friends who do family law, don't let them leave the room. If they're separated, they get hit by a bus on the way out. You know, you've got yourself a situation of a state administration that's going to be in a bit of chaos because you're separated and your spouse may be your executor. So you've got administrative issues as well. And so I get actually quite nervous when someone says, "Oh, I'm separated. I haven't, you know, done anything about my estate planning," because of course you can't predict when we're going to die. And so I agree with you 100%, and I say it loud and clear whenever I'm at it.
Well, I remember what I did was something you would probably not say to do, which was I'd been separated for a year and I was going on vacation. So I simply wrote a holograph will before I left. And for those who don't know what that is, it's something I wouldn't recommend anyone doing, which is you take out a piece of paper and you write it out in handwriting. So it's one of those times, don't do as I did, but do as I say, because it's not a smart move to make.
Maybe the only stopgap you had, so I still applaud you.
Well, I had months to take care of it the right way before that. Here's another question. Prior to divorce, my in-laws paid for my children's college education. Since then, my in-laws have passed. Is there any obligation of the estate to continue paying?
Well, that's a really good question, because in short, there may be, And in fact, depending on the circumstances, it would be a claim for support from the child against the estate. And if you can fall within the definition of the Succession Law Reform Act as a dependent, and that in and of itself is not hard to do if you're a grandchild or you're treated as a child, like a child by your grandparent, you might have a claim for support, and it's a direct claim actually from the child who's receiving the support against the estate.
Now, this is one of the things we get into family law about gifts, because we have now grown into a society where if someone is being generous and being helpful, there can actually be consequences to it. There's a family law decision a couple of years ago where the grandparents were paying for the private school tuition. And when the parties separated, the court found that those payments were actually income to the husband, and then did a gross up on them to account for the fact he didn't pay taxes on it, and then made him pay support on those gifts. And it's the same kind of idea that somebody is being generous, typically the grandparents, and now they're being called upon to make payments as a result of the generosity, whether it's the estate or while they're living, in essence, the father was going to be called upon to make more support. So it's a real message that if you're going to give gifts, you have to think about the consequences of giving regular gifts, because you may be called upon to do it over and over again.
Yes, and it's an unpredicted obligation. First of all, no good deed goes unpunished. So you get in the situation where you created a pattern of gifting, and when you pass away, you may or may not know that you've actually created an ongoing obligation for support under the Succession Law Reform Act. And it can be a big surprise to the executors, and it can be a big burden on the estate. If there's been significant payments, the courts have been very generous, and they expect the deceased to have continued those payments in the right circumstances.
And would that impact the trustee's ability to deal with the estate on a final basis then, because they'd have to make sure there's enough money there to fund this?
Absolutely. And there's some limitation periods on that claim. So those who want to make those claims have to move within 6 months of getting probate in Ontario, for example. But typically executors are going to want to make sure that any of those potential claims are exhausted. And when I see a client who's an executor, I always ask, I say, look, do you have any sense of any financial obligations? When it was the deceased sending a package to someone, in Europe once a week, was there any sort of sense of having a gifting obligation that could continue?
So I think part of this, the fear is, I look at it from a family law perspective, it can create an income stream. And the other interesting thing that dawns on me is I picture the family where they may have 2 or 3 older kids and then they had a child later on, because there may be an argument that if the older kids had their university funded, there was an expectation that the younger one would have the same benefit, which I could see then really creating a problem for the executors at dispersing funds.
And and you add on the layer with, you have a minor child, the Office of the Children's Lawyer in Ontario, but any of the provinces have government agencies that monitor claims of minor children. And that's exactly the type of claim that they will make.
Okay, now I see we have another question came in on Twitter. Can my ex-common law spouse go after my inheritance? I'll take that from a family law perspective. The answer at first instance would be no. However, there is an issue that if it's a big enough inheritance that's going to generate an income stream for you on a going forward basis, there may be an income there that warrants additional, there will be an income that will warrant additional child support and maybe spousal support depending on certain factors. So, you may hear from family law lawyers regularly saying an inheritance is excluded and they're not going to get any money from it. Well, you're not going to get from the capital if you deal with it properly, but you may very well get from the income stream, and you always have to remember that. Another example is I had a gentleman say to me, well, I have a client who may inherit the house he's living in because he lives there with his parent of $1 million. Well, at least in that scenario, the courts do understand that you need a place to live. And you're not going to generate an income stream from the place you're living in unless you're a single person living in a $6 million home. Then they can say you have too much house. We had a question that came in on my Facebook account just before the show started, and it was a lady who asked, it's a short-term marriage, and my spouse is asking to claim as a deduction his contribution to the matrimonial home that he made. And that really brings up a whole host of questions from a family law perspective, because typically, and this one shocks a lot of people, if you get married and you own a matrimonial home on the date of marriage, and it's still the matrimonial home on the date of separation, you won't get a deduction for it. So in other words, if you have $100,000 in a bank account on the date of marriage and you can prove it, you get a deduction. If you have $100,000 of equity in a home on the date of marriage, and you still are using that house as the matrimonial home on the date of separation, you won't get it. If it's not a matrimonial home anymore, you will get it. So it creates a whole host of problems. And the extra layer for this particular question is if it's a short-term marriage, which is considered less than 5 years, but you include the common law period, you then can argue that it would be unconscionable to equalize the net family property. I think of one case I once had where a man came into my office and he had no mortgage on his house and was worth about $500,000, and he was married for a year. And the wife wanted half of it. And we took the position she should get nothing. He owned this home with his prior wife, and eventually the other person went away and we never had to litigate it. But that's a perfect example of where you might say that would shock the conscience of the court and that you might be successful. I see we just got another question coming in. This one is by text. My spouse has a child from a previous marriage. We have no children together. If I die before my spouse dies, our matrimonial home, or will my matrimonial home pass to my spouse's child? I think that's really for you, Ian.
Yeah, I mean, it depends on the will for sure, and whatever the estate planning steps that have been taken. But you know, it ties into your last response, and the one that I think, you know, the only message I keep telling my clients when they do their estate plans, there's an ongoing obligation to support. And if there is a child involved, there's going to be some element of support that's going to be maintained by the courts. Like you say, I'm not sure they're going to get the house, but they have a serious claim for lifestyle expenditures the rest of their lives. And it may turn out that that's what the house is worth.
Now, this may not be an exciting topic for a lot of people, but would I be correct to assume that a smart move by people is just to buy some additional insurance, especially when you're getting into second marriages and there's children from first marriages, to at least be able to have enough money that it allows for things to go around for everybody?
Yeah, absolutely. And, you know, I'm not an insurance salesman and I don't make anything from that work at all, but I can tell you that a lot of my clients don't even think about things like, well, they say, well, look, my health isn't great. Well, you've got a marriage situation, you've got a last to die policy. The insurance companies tend to be pretty flexible in terms of those policies as well. There's a lot of insurance options that to get a good agent looking at. Don't just say, no, well, I couldn't imagine passing the physical, because the insurance option still is the single easiest way to manage all of those problems.
And then what you're really doing is you're giving your children and your either first spouse or second spouse, whatever your arrangements are, peace of mind that hopefully they're not going to be burdened with litigation for years to come because there's enough money for everybody.
That's right.
And to me, that's a really important issue. Do you find when clients are coming into your office that they're aware of how divorce and separation may impact them in other ways that we haven't discussed from an estate planning perspective?
I would just say trusts. And if they've got trust arrangements, family trusts, you know, any kind of arrangements that are tying up assets through a trust scenario, I think that's where I would say a large part of my clients don't have a group of beneficiaries of the trust could include your spouse. And sometimes people don't understand whether or not they can consider whether or not they can, you know, get rid of that clause, or how they manage that, or what if your spouse is a trustee of a family trust? How do you get that logistic worked out? So I always like to, you know, really drill down on what are we dealing with in terms of assets and what entitlements you have or what responsibilities do you have, because divorce can have a major impact on things like that.
There's a couple things I see sometimes with trust that I find fascinating is when a client comes in and they say, well, look, Andrew, I'm just one of the beneficiaries of the trust. So the income that's flowing into the trust every year, that shouldn't be considered mine for support. And I say to them, but the problem is the last 10 years you took all the income out. So nobody's going to believe it's not really yours. And you know you have a problem. That's one common theme I see. I've actually, the other theme you see is some clients will get the idea of, I think I might be splitting up with my spouse. And this is more second marriage scenario. So I'm going to put the shares of my company into a trust for the benefit of my children. And they don't appreciate that if you're doing it on the eve of a separation, if it has a funny smell, it probably is going to have a problem versus a scenario when it's done 5 or 10 years before. And I think it's much like you said earlier on in the show, Ian, and you'll correct me if I'm wrong, especially if you're being transparent with the current spouse that this is happening, they're going to be a lot less likely to contest that transaction because they won't be shocked to hear about it.
Yeah. And, I call it 5 minutes to midnight estate planning. If you do that in the estate planning context as well, it's not going to fly. The Court of Appeals did the leading case on that point. They just said you can't dissipate all your assets just before, and you're very ill, somehow take these assets away from your wife and give them to your kid. They just clawed them back in. They're going to do it again. So if you've done careful estate planning transparently, then these things actually do work.
Now, I would say with marriage contracts, I don't do them anymore for certain reasons. And a lot of family law lawyers don't. But I say to people, if you are going to do a marriage contract, it's usually in the context of a second marriage, and there's usually insurance provisions and what is going to the second spouse. I say you got to work with your estate lawyer because you want to make sure the contract and the will are mirroring one another where appropriate. And I don't know if you do that kind of work as well.
Yes, I know, I agree, and we do, and that, as I say, that's a real focus. The commitments you have made prior to making your will are almost always binding. I mean, when you get into a car lease and you die, the car company doesn't say, "Oh well, we're sad about your death. Let's rip up the car lease." It's something that I keep coming back to my clients and just assessing what have they got themselves into, corporate arrangements, agreements, all of that, and then. It's not that we can't deal with them. It's a question of managing. And, some people won't tell us or they're reluctant to give me all that information. I just say, look, I've got to have all the information I can have because I'm going to be able to give you suggestions on how to manage what may or may not be a problem.
I mean, I look at it and I say, I can't imagine the scenario where the marriage contract creates one obligation and then the will to the second spouse creates a lesser obligation. Obviously, it could create a greater obligation or a greater payment to the second spouse, but if it's less, you can just see the litigation that's going to flow, especially when the children don't appreciate it. And not so much estate planning, but I know you probably do powers of attorney as well. And I don't do them, but when I have a discussion with my client, I now say to them, you need to think about who you're picking as your attorney. Just because you have adult children, when you've been divorced, you probably don't want to pick that adult child as your attorney because who are they probably going to go to make discussions on end of life? Most likely they're going to that other parent. And
power of attorney work is growing. The aging population is, I sort of describe it, we're kind of about to have a massive passing of wealth on, and everybody talks about the great transition, and that's fine, but we're kind of in a limbo and a gray area. And capacity issues and in the aging population for people who are still alive and family members who are tugging on each side through use of the powers of attorney is a real growing, contentious part of my practice. And it's a bit unfortunate because truthfully, it's a terrible legacy. The last 5 years of your life, the family's fighting over these kinds of issues while you're alive.
I can't imagine that. And I can't imagine being in the situation where you name your child and then your child goes to the former spouse and says, well, mom or dad is in the hospital. Should we or shouldn't we continue on with their health? And they're asking the person who may hate you more than anyone else in the world. And I don't think people naturally think of that. They just think it's my child.
Yeah.
So, I trust my child. You got to think about that. So here's another question coming in from text. My husband and I are joint owners of one house. Can I legally will my half of the house to someone else in the family?
So you need to put the house in tenants in common to be able to distribute that 1/2 interest of your house separately from your spouse. Right now, there's a survivorship. If it's joint tenancy, it would roll over to the survivor, and in that case, it would go outright outside of the estate to your spouse. So you need to sever the joint tenancy, and then you have the rights that you can distribute that 1/2.
And I would add, that's one of the things we recommend to our clients when they first hire us. And the first set of documents we see is we suggest that they sever joint tenancy. Albeit it's a judgment call, because you might think, well, my spouse is sick and I may want to benefit from it. There's some case law that says you may not need to do that once you're separated, but it's still a smart thing to do. And it's not very expensive to do. But one of the things you always have to ask yourself too is, what legacy are you leaving to the people you leave behind? So if you were married, especially if it's a first marriage, and you're making a choice not to give half the house to your spouse, you're leaving a legacy and a memory that's going to probably leave them very angry at you for that, especially if they get forced out of their home. So I think you probably have discussions with clients all the time about the legacies they're leaving behind by the decisions they're making.
Oh yeah, any unilateral steps in an estate planning scenario, first or second marriage, can lead to a disaster, both emotional and litigation. So I carefully go through it, and I really don't. Sometimes I don't understand why clients are doing what they're doing, but I don't always have the full story. I just make sure they understand. Like you say, I don't let a client sever a joint tenancy unless they know exactly what they're doing, both legally and what impacts it may or may not have in their current relationship.
Okay, now, prior to getting married, is there anything that you recommend people do to protect their estate and trust beyond the obvious, which I always say to people, get a marriage contract. That's the best route. But if they're not getting a marriage contract, is there any suggestions that you have for them?
Well, and most don't get marriage contracts in that situation because they're entering into a happy situation. And as you know, in your world, it's hard to convince them that things go bad at that point in their lives. I think assess your assets and the holdings where, as you've already described, the matrimonial home is going to be treated in a special way. If inheritances come in and the money goes into the matrimonial home, it's going to be excluded, as you've described. But I'll just say to them, look, depending on your assets, you have to sort of determine what kind of emotional change you want to bring to the relationship by maybe trying to exclude the new spouse from ownership. It's always a difficult conversation, but I ask my clients to, before they're getting married, just to sit down and put together a list of your assets. Who's got the ownership? Where would you anticipate that ownership to go? If it's always been the intention that asset, the corporation, would pass on to your new wife in your mind, then that's fine. But think 2 steps ahead. I always say take 2 or 3 chess moves and then decide what you're going to do.
See, and as a family law lawyer, I take very simple viewpoint, get a contract. And as I said earlier, I don't do them, but when I have the clients who walk out of my office with a significant net worth or significant income stream, and they've already repartnered and someone is living in their home, I strongly encourage them to go get contracts done. And the thing I really need to say to people is, a lot of people will think, well, I'm not living with them, so I don't need to get an agreement done. And I remember when I was single as a divorce lawyer, my fear is that people don't appreciate if you're spending 3 nights a week with somebody, a court may say, well, you are living together even if you have 2 homes. And I thought to myself, how do you ever ask someone for a cohabitation agreement when they're going to look at you like you're crazy because you're in 2 different homes? And I see your reaction off screen, and right now, or both screens, but right now it makes me think that you probably have a similar discussion with people from a Succession Law Reform Act perspective.
Absolutely. We have a tremendous amount of litigation in our office just fighting over whether or not you qualify as a spouse. And the courts look at like a variety of factors, probably over 25 factors, as to whether or not you're a spouse. And I can tell you, like you say, 3 nights a week visits, different floors in the house, all of the indices of what a relationship and a spousal relationship are changing every day by the courts.
The thing I say to people as we're just finishing up is, I always think of what judges have said at conferences, which is first they do what's right and they make the law fit. And that I think frequently happens in family law. Is it the same in estate law?
I think so. It's not quite as my experience is the state law is driven a little bit by more of the academic history and case law and so on. Is so ancient that it's driven some of the patterns. But yes, absolutely, I agree. Judges are going to do what's right.
So, Ian, I wanted to thank you for being on the show as our time is up. It was a pleasure having you, and I certainly learned some new things today. For anyone interested in learning more about Ian and his wills and estate planning services, please visit his website at Hull, Hull, and Hull.com. The next Ask Andrew show is on February 15th, 2018 at 1 p.m. If you have any questions or show ideas, February 15th, 2018, I said the wrong date. If you have any questions or show ideas, please email us at info@feldsteinfamilylaw.com, and thank you for watching.